grandfather of an accused killer is expected in court. We're talking about Colin Gray requesting a change of venue from Barrow County due to the high-profile nature of the Apalachee High School shooting case. Now, prosecutors say he gave his son an assault rifle that allegedly was used in last year's shooting, ending up in the loss of 2 students and 2 educators. It is really a tragic story out of Barrow County that continues to plague that community and really weighs on the minds and hearts of Georgia. Here to talk about this case and really what today's court hearing will involve is criminal defense attorney Josh Schiffer. And Josh, this story, we've seen Colin Gray in court before for bond for a first appearance. This is different. This is a request for a change of venue. So take me through the basics. What is that request?
Yeah, this is a really substantive portion of the criminal justice process. So far, we've seen a lot of almost administrative functions, the setting of bond, the probable cause and commitment. That's standard stuff. This is something that is very specific to this case. It's being brought by defendant Colin Gray, the father of Colt Gray, who was accused, of course, of the tragic shooting here at Apalachee High School in Barrow County. So just step back for a minute and let's talk about what's happening and why venue is so important. Venue is just place. It's where the case is going to be heard. Georgia has 159 counties, 159 superior courts, and in Georgia, as well as really the rest of the nation, wherever you're accused of committing the crime, that's where they're supposed to pull the jury from. That's the jury of your peers in that community. If it's in Fulton County, you get a Fulton County jury. But what happens if that jury pool has been affected just by the coverage, just by the information, the allegations being made by the news media, by local coverage, by gossip in the community? That can really impact the fairness of the trial when a trial is convened. So in order to ensure the defendant's constitutional rights to a fair and impartial jury are met, very often in high-profile, big incident cases, the defense and sometimes even the state will move for a change in venue. That doesn't change the judge, it doesn't change the prosecution or defense team. What it does is it changes the jury pool and the actual location of the trial. The jury pool is selected from people that have registered for jury service. It's connected to our driver's licenses now. And it really is a large cross-section of the community because the Constitution intends you to be put on trial before that wide cross-section of the community. It's not people just like you, it's people in your community. The fear of the defense in this case is the community has been so traumatically affected by the deaths of these children in a high-profile school shooting that it would be impossible for the court in Barrow County to assemble a fair and impartial jury. So the defense is asking the court to move this case to a similar analogous community in Georgia. Now, the good news is that there's a lot of communities for the court to consider. Barrow County is a little bit of an ex-urban community, northeast of Atlanta proper, kind of out in between Atlanta and, say, Athens on that 85, 316, 20 corridors. So there are several analogous communities, similar demographics, income levels, populations. Those are the issues that the court is going to consider when determining if a venue change is proper and then where a venue change move would be. A lot of this has to do with convenience of the courts. The judge is going to have to be there, and the judge's staff, and the defense and the prosecution. It's moving the whole show to a different community. So convenience matters, but most important, trumping everything, is the integrity of the trial. This change in venue motion by the defense can be considered the first blow against an attack on the state's allegations. It's the defense saying, hey, it's impossible for us to get fairness here. Give us a different venue, otherwise the results of this criminal prosecution may be illegitimate. And bluntly, they're making a really good point. If there is a case that has this kind of community impact, it's one that involves the murder of a bunch of local kids. There's no way that the entire community of Barrow County is unaware of this horrific tragedy. It covered the news from morning till night. This was obviously a common discussion topic. And if I'm the state, I'm not going to fight this too hard. I'm going to use this to my advantage and try to encourage the court to select the best community for the state's case. Meanwhile, the defense is going to possibly be moving into communities that have a more traditional defense-minded jury pool.
And, you know, we talk about the two sides of this and the arguments that could be made. You bring up the prosecution, the state's side. Wouldn't the best case be to argue to keep it in Barrow County?
The best case is that it's the community that's been injured and that there's a duty and there's a familiarity. The local community is the one who selected the prosecutor that is going to be bringing this case. Even if it's not the elected district attorney, it's representatives from the elected district attorney's staff. And keeping that strong community connection is something the state wants. The state wants to be drawing a jury of people that are going to be open and familiar with the facts, the locations, the people involved potentially, and the impact on the community. That is why our Constitution talks about our jury rights being people pulled from our communities. The state generally benefits from having the trial in a place where the alleged crime is well known. At the same time, the state has to be aware of the collateral attacks on the process, the integrity of the trial at hand. The state doesn't want to try a case twice. This is already a novel case. Remember, we're dealing for the very first time in Georgia and the second time nationally with the idea that a parent can be responsible for keeping a firearm where their child can access it and then commit a crime. This is a big jump when it comes to traditional criminal justice and criminal prosecutions. It is the second time in the United States that this particular concept is being applied in criminal courts after the prior case up there in Michigan, tried by my good friend, Miss Smith. This case, its integrity really matters. So, that being considered, there's a lot of good reasons that the state should just silence, cut off at the pass any legitimate attacks on the criminal justice system, venue being an easy one. I think that the defense has a strong argument that everyone in this community knows about this case, has heard all kinds of information, true or false, it doesn't matter, but has received enormous information and familiarization with this case, and would be very difficult to rehabilitate them into a position where they could be legitimate, independent, unbiased jurors. And I think that trying to establish a unbiased and appropriate jury might be a folly, a waste of time for the courts. So I don't expect the state to really push back as hard as they could in order to preserve the integrity of the trial, a trial that they know is going to be long and complex and have plenty of other very real issues to argue about.
Well, Josh, can I ask you bluntly, what county contenders are we talking about here?
You know, you could talk a lot about maybe a Douglas County or a Cherokee County, something similar in nature to the ex-urban from the core 5 county area that we traditionally think of as the main Atlanta area. This is not a Cobb or a DeKalb or a Fulton, but it's one more ring of counties out. So I would definitely consider any of the counties going down 20, either west or east towards Alabama or South Carolina. You could also look south of Atlanta, getting towards Macon. In fact, Macon, Bibb County might be something that the defense really would like, considering some of the demographic trends that you see. But it really becomes a personal decision by the judge when they're reviewing the available communities.
And, you know, we talk about Colin Gray, the father of the accused Apalachee High School shooter. Let's talk about the main suspect, Colt Gray, his son, also requesting a venue change. Could we see the outcome of today's hearing with Colin Gray, Colt's father, weigh in or foreshadow what could happen with Colt?
I think foreshadow is definitely the right term. The impact of this incident is the same on the community regardless of whether you're Colt Gray or Colin Gray. Those arguments from the defendants are going to be similar in that it's impossible for them to receive a fair and unbiased jury pool, jury process, and eventual trial because of the notoriety and the coverage of the shooting. So whatever goes for Colin, I pretty much expect will go for Colt. The question then being, is it the same community? Does the judge choose to divide it? There's a few details that are yet to be decided during the process. I'll be eagerly awaiting to hear the arguments made by the state, whether there are preferences made by the state prosecutors or the defense team when it comes to specific counties or communities. The big last one of these, remember, in Georgia was the case down in South Georgia. The Ahmaud Arbery case with some very substantial venue issues. But it's not uncommon. I also always go back to the crematorium case, where there was a huge crematorium crime with bodies being inappropriately handled. That ended up being a change in venue because everybody in the community knew someone that had been affected by the particular defendant crematorium.
I want to talk for a moment about Colin Gray's charges as we wait for this hearing to begin. He faces the harshest charges of really any parent of a suspected school shooter that has been reported. 2 counts of second-degree murder, 19 counts of second-degree cruelty to children, 2 counts of involuntary manslaughter, and 4 counts of reckless conduct. He has pled not guilty. So what is the likelihood that these charges lead to a conviction?
I'm going to say right now, very high. There's a lot of strategy involved in the manner and method the state brought those charges. Some people are going to accuse the state of stacking, but there are legitimate justifications for each and every one of those charges. In trying to figure out the appropriate resolution, a lot's going to be going through the minds of the stakeholders. Colin Gray may say, I'm not going to take a day of time. I'm not going to plead to anything that is going to put me in prison because all I did was exercise my constitutional rights to possess a firearm. It's not my fault that my child took it and then committed a crime. Remember, in the criminal justice process, you don't need 12 for an acquittal. The state needs unanimity for a conviction. But the defense just needs 1, 2, 3 brave jurors to stand up and say, no, I'm not going to agree that the charges have been proven beyond a reasonable doubt. With a novel case, with a novel theory of prosecution, with this culpability being transferred between the father and the son, that's such a new issue. Cleaving out 1, 2, or 3 jurors is much more likely than with a non-novel, run-of-the-mill, drug possession, murder, something like that. You really have the opportunity to get into the ideology, the brains of the jurors, and if you can pick one of those, poke it, stimulate it, that's a strong pathway to an acquittal for such a novel charge. That's also why they're probably going to be doing Colin before they do Colt. Colin's charge is much more difficult for the state to carry as opposed to what I expect they're going to carry against Colt. And they may eventually end up in a position where they want to offer Colin Gray some sort of deal, and potentially that deal would include some form of cooperation against maybe even his son.
Wow. And we will continue to follow all of that with every one of these developments, starting with today's hearing. You mentioned earlier you see this venue change request being granted. So what happens next for the defense and for the state in their strategies?
Well, I expect the judge to rule not immediately, but relatively quickly. The judge wants to ensure this case continues moving and certainly does not want to be seen as one of the barriers to a speedy trial. So I expect the judge is going to rule relatively soon. And when the judge rules, the judge has the prerogative to have already made all these decisions for everyone. The judge can also go back and have another process for determining the location. So really, it's going to be up to this judge and how the judge wants to handle the trial that they have been assigned. Once a Superior Court judge in Georgia is assigned a case, they run the show. They're the captain, the admiral, the general, everybody. It is very hard to tell a Superior Court judge what to do or how to do their job when it's their case and they've been elected by the community.
criminal defense attorney Josh Schiffer joining us here on Atlanta News First Plus. I always appreciate your expertise and how much you explain and break down these complex cases. Of course, this one has a lot of emotion within the community, really across the state, wrapped up in it. And so we'll continue to follow and bring you every single development. But I just want to open the floor up to final thoughts, what to watch out for as we get ready to take you live into that hearing.
Really, the demeanor of the state matters a lot to me. There's a good justification, in my opinion, for the state not to push hard against the defense motion. This is an issue that, say the state wins, it's automatically going to be subject to an appeal. And whether that is an appeal prior to trial or whether it's appeal after trial in the middle, who knows? So from an integrity of the criminal justice process, it may not be in the best interest of the state to push hard against a change in venue, especially given the notoriety and novelty of the case at hand.
We encourage you to download the Atlanta News First app on your phone. We will send you push notifications on major developments in this case and community stories in Georgia and here across Metro Atlanta. Josh, thank you again so much. We are going to take you now to a brief commercial break. Coming back, we will take you live into that courtroom where Colin Gray is expected to be with his attorneys requesting a change in venue in the case he is facing tied to the tragic Apalachee High School shooting last September. We'll be right back.
I think the court can take judicial notice of the amount of publicity that has been generated. Secondly, Judge, I'd like to point out that certainly this was a tragedy. This community came together and did an awful lot, fundraising-wise, GoFundMe-wise. I think when I checked last, it was over $1 million that had been collected from the people in the community for the victims in this case, which I think goes to show how the community felt about what happened, which bears on our change of venue motion. There were a number of fundraisers that were had. I think Texas Roadhouse, all over the state of Georgia, gave money for one particular day, everything that they brought in to the victims. And one of those, I think, was over in Athens. There was a car show, brought in over 1,000 cars. I think they made $40,000 in that. That was at the Home Depot. There is the Barrow County Community Crisis Fund. I think there are 10 members of that fund. Community leaders, people who have been elected to positions in the county, clergy, a person who has the most employees in the county. And certainly that sphere of influence of that large number of people reflects also in the community feeling about this case. They sold T-shirts. There were yard signs that were put out. I know the first time we came up here for Mr. Gray, we went out to downtown to eat. The restaurant had Apalachee Strong. We saw a number of those as we were in the downtown. There was a motorcycle ride that was done for fundraising, as well as I think the Blessed Trinity High School over in Decula did a fundraiser. Smoking Poor Boys Barbecue did a fundraiser. There was a golf tournament also. So I think all of these things, Judge, go to point out that there was a lot of community feelings about the case. People who are willing to give money certainly would have a prejudice about what might happen in a trial of a case. For all those reasons, Judge, we would ask the court to grant our motion to change of venue if the court does that, we'd like to argue over where we think would be an appropriate place to send it.
All right, I'll hear from the state and then we'll come back and address that.
Your Honor, the state agrees in changing venue from Barrow County. However, the state does not agree to change the venue because of pretrial publicity. And there's a distinction there that will be used that addresses the remedy of what we should do. The reason the state is agreeing to change a venue from Barrow County is because all of Barrow County was a victim in this case. This was an attack on the school system, all the teachers, all the administrators, all the students. Just about every school on that day was in lockdown. Parents with children in elementary schools, middle schools, high schools across the county were worried about their child that day and was impacted by this. So therefore, we believe that because of the impact of the crime on Barrow County, that it would be difficult to find a fair and impartial juror, and it's the state's wish to try this case cleanly, one time, to bring justice for the citizens of Barrow County and the victims in this case. So therefore, we're agreeing to change the venue, but not because of pretrial publicity. In Miller versus the state, 275 Georgia 730, court says that pretrial exposure to information about a criminal matter is not the same thing as pretrial exposure to inflammatory or prejudicial material that threatens an accused right to a fair trial. Being informed or even misinformed is not always the same as being inflamed or prejudiced. Even in cases of widespread pretrial publicity, situations where such publicity has rendered a trial setting inherently prejudicial are extremely rare. That case, Your Honor, discusses some factors that they look at, but it was more fleshed out in later Supreme Court cases. In Gear versus the state, 288 Georgia 500, that's a 2011 case. Powell versus the state, 297 Georgia 352, a 2015 case. Mims versus the state, 304 Georgia 851, a 2019 case. And Overstreet versus state, 312 Georgia 565, a 2021 case. I have copies of all those also, Your Honor. These cases are basically all the same, Your Honor, and they just keep reiterating the same factors that the court would look at. And those factors being, the record must establish that the publicity contained information that was unduly extensive, factually incorrect, inflammatory, or a reflection of an atmosphere of hostility. And I don't believe the record shows that, Your Honor, in this case. None of the things that came about, all of the newspaper articles were basically about this happened. It was people were arrested. There was a grand jury. There was a preliminary hearing. All things that were just factual about the process and what had happened. Facts of the case are things that will come out during the trial. There were not things that were incorrect. There were not, most of the articles were about the shooting itself, which was perpetrated by Colt Gray, not Colin Gray's participation in that, Your Honor. So we don't believe it's been established that the pretrial publicity is inherently prejudicial. So therefore, that is not the cause of the change of venue. And if it's not the cause, then where you go to pick your jury changes. If pretrial publicity is a problem, you're also not going to fix that by moving anywhere in Georgia. You've had the same publicity throughout Georgia, throughout this time. The Pew Research Center did a study on news consumption across platforms today. This is from September 17th of 2024, and said 86% of the U.S. adults say they sometimes get news from a smartphone, computer, or tablet, including 57% who say they do so often. 58% of Americans say they prefer digital devices, far higher than the share who prefer TVs, which is 32%. If you look at the markets across Georgia where people could be getting their news from, you have Atlanta, Macon, Savannah, Augusta, Columbus, Chattanooga, Albany, Jacksonville. Those are the places that have local news stations. All I did, Your Honor, was I did a Google search of News Savannah or News Chattanooga. Google search pulls up 5 or 6 news stations. Click one, any one of them you pick. The one I did was Fox Chattanooga. And then you just search in their search, Apalachee. 56 results came up on Fox Chattanooga news search for Apalachee. Did one for Columbus, same thing. This turned out to be WTVM from Columbus. 126 results. Albany, WALB, 159 results for Apalachee. Augusta, Georgia, 238 results, one station. Savannah, Georgia, WJCL, ABC affiliate, 30 results. Macon, WGXA in Macon, 58 results. Your Honor, wherever you go, these reports are there. The same news is being shown on the same television channels anywhere you go in Georgia. So if publicity is the thing you're trying to get away from, you're not going to solve that going to any other county in Georgia. So if you're not doing that and it's not fixing the problem, you have to find something else to choose that county. And the more complexity you add to this process, the more chance for error. And so the state's position is they want the least amount of complexity to this trial. Factors that should be considered are in OCGA 17-7-150. Instead of pretrial publicity, we should be looking at the hardship of sequestration and distance from home on jurors, the comparison of court space available. Remember, these counties we go to have to have court space not only for us, but their own courts that are going on at the time. Comparison of the security, jail, clerical, and support staff. Do they have the abilities to take this case on in their jurisdiction? The cost to conduct the trial in each place. The impact of the trial on the orderly administration of justice in each county, there and here. Remember, our officers are going to have to go there to help with security. Well, who's left here to patrol the streets? Who's left here to run the courthouse security in this courthouse? We'll still be having cases going on in front of other judges. The impact on the witnesses in this case. The availability of hotel accommodations and meals for jurors in each county. And don't forget, the state, counsel for the defense, witnesses, security, they're all going to be staying at these same hotels, eating in these same restaurants. The press has been following this case diligently. They're going to be staying at these same hotels, eating in these same restaurants. The more complications you add, the more opportunity for error in a case. The effect of the prosecuting attorney and defense counsel in each county, that just stands, Your Honor. And all matters which would affect the fair trial and orderly administration of justice, which is what the state is most worried about. The more complexity, the more opportunity for error. Demographics in the case, Your Honor, this keeps popping up. I don't know why, although I did want to put this in before I move on to that. Your Honor, we did get one of the things is the hardship on the victim's witnesses in this case, and one of the issues is going to be the school system itself. And we have a letter from Matt Thompson. He's the chief of staff of Barrow County Schools, and it's basically just talking about the impact of moving this trial on the school system. If you remember, most of our witnesses are coming from the school system, and it mostly talks about how teachers are going to miss potentially multiple days of instruction. Who's going to cover that lapse of the students that aren't participating in the trial but need instruction from those teachers? How's the school going to pay for substitute teachers to do that? The effects of counseling on the students that are going to be going down to testify and the emotional impact that will have on them. And those are in the letter that we received from him, Your Honor, and you can read that your own.
You want to mark, just for the record, you want to mark this, the letter?
States 1, Your Honor, that'd be fine.
No. You admitted to states 1.
Your Honor, when you move the county, a lot of people have talked about demographics. I don't know where in the case law why that's important, but it seems to be important. I would argue that the most important demographic is that it is a county of similar size of us, in that they could then therefore accommodate what we would be bringing to them. But I do have, if you want to talk about demographics, I do have statistics on that, but I'll not do that at this time. What the state would propose, so that there's less complexity and least amount of opportunity for error and least amount of hardship on everyone, is that we pick a county of similar size to Barrow County that is in close proximity to Barrow County. We strike a jury in that county. We try the case here in Barrow County. We would also suggest if you strike a jury in a county close enough to Barrow, those jurors could spend the night in their own home, drive to a location in their county in the morning. The sheriff's office could have a van, or they would have civilian bailiffs drive them to court. If we started court at 9:30, 10 o'clock, finish court 4:30, drive them back, they go home to their own homes. That abbreviated court day would only add 1 or 2 more days to the trial in total, and would be more convenient, less costly, and have less complications that could invite error to this case. The state, based on the demographics that we've run, believes that Walton County would be the most suitable county, in that they are similar in population. They have a similar breakdown of white non-Hispanic, black non-Hispanic, and Hispanic populations to Barrow County. I don't know how much the breakdown of race matters in this case. This is not a case that bears on race. This was indiscriminate. There does not seem to be a targeting of any particular person or type of person, but we do have all races, or those 3 races, represented in the victims in this case, Your Honor. And that is the argument I have at this time.
I do have a question.
Yes, sir.
Too. So today's world's different than the world was 30, 40 years ago.
Yes, sir.
Back then, everyone got their information from a newspaper or TV. Now, not only do we have online media, so when we're talking about pretrial publicity, does that extend to social media? Because my guess is the social media that in Barrow County, in the nearby area that's talked about the case, is going to be much more significant and probably inflammatory than any social media further away from the epicenter here. Does that factor in on the pretrial publicity?
It does, Your Honor. I think there are 2 separate issues on that case, Your Honor. Pretrial to publicity is talking about what is being given to the people. It is my experience with, and my understanding researching this with the Pew Research Center and some of the stuff we've done, is that you will have a local, there is national coverage. We've had national thing, but most of the stuff that people here are seeing is going to be a local news station that was close enough to send somebody up here. They would then have their news broadcast, and that could be broadcast, let's say, on the Atlanta, out of the Atlanta broadcast area. It used to be that was the big deal. So, okay, Atlanta's broadcasting it, let's move somewhere outside of the Atlanta broadcasting area. But what happens in today's society is that same news thing is then picked up by the Macon affiliate, the Savannah affiliate, and it's shown again. It's picked up on Facebook and sent to people on Facebook. It's picked up on YouTube and sent to people on YouTube. So where it used to be important as to what the broadcast net area was, now it's not important because it's sent all over the world. I mean, anecdotally, I get calls from high school, college friends that I haven't talked to in decades. They're calling me from all over the United States that they saw this. Like this is happening everywhere. And so what I'm saying is you're not going to fix that with pretrial publicity by moving it. Now, when you talk about people on their own, citizens typing something in Facebook and sending it to their group, that's a whole other issue. And I don't know how we can ferret that out. It's pretrial. That would have to be something that had to be ferreted out during jury selection, which is one of the reasons we would suppose that is higher in Barrow County because, like we said, of the direct impact. But I don't think it changes based on Dougherty County or Effingham County. I'm saying I don't think that changes that narrative.
Are there, and I realize you're having to address this before the defense has suggested places for the trial. Are there other counties that the DA's office thinks may be appropriate? So just candidly, a concern I have with Walton is it is right there. So there are going to be people that live in Walton that very likely have family members that live here in Barrow County, or their cousin or their child's best friend goes to school in Barrow County, and they're just right there in Walton. So that in my head, I've kind of used a nuclear blast analogy, and it's then you've got your nuclear fallout. The closer we are to that epicenter, the more likely we are to have jurors who have been affected or experienced some of the pain of what's happened.
I would agree with that, Your Honor, and especially geographically, Apalachee lies closer to the Walton County line. We picked Walton County, and I just specifically said Walton County because demographically, it's the most similar to Barrow County. Actually, I didn't misspeak, but when I ran it through the computer and asked it to what's the most similar to Barrow County, but skew it towards population, give population a higher value than the split of races, being that the split of races is not really an issue in this trial. It put Jackson County as the most like Barrow County. there will be significant evidence about the defendant used to live in Jackson County and go to Jefferson schools. So that's why I left Jackson County off, is that you're going to have actual witnesses from Jackson County. So I left Jackson County off for that particular reason, Your Honor. But Walton County also is, like you say, geographically close to the actual school of Apalachee. But if you take out percentage of white, percentage of black, percentage of Hispanic, percentage of Asian, you take that factor out and you're just looking at population sizes, Hall County, Gwinnett County, these other counties that are near us and when drivable distance, that would take that consideration out. The only reason I said Walton County is because for some reason people keep bringing up this demographic thing, which I don't understand why that would be important in this case.
You don't see a requirement in the law that we adhere
I think
to this sort of...
I think it more comes up in death penalty cases. And I think there's a difference between death penalty cases and non-death penalty cases. I've not seen it in the case law I've brought up about, but I know it comes up all the time. People discuss it all the time. So we did run the demographics. I don't think it's important in this case. I don't think it's an issue in this case. To me, it's more, because some of these, when you run it, like it had, one of them I ran, it had like very similar to us was Chattahoochee County. They have a total population of 8,000. Ours is close to 100,000. Like you can't have it there. So I tried to take, ours is more like, where can we feasibly have it with the less opportunity for error? And that is what the state wants. They want to try this case one time. They want to try this case cleanly and bring justice. So that's where we are.
Okay. Thank you.
And Your Honor, we do have the sheriff. I don't know if you want me to call him now or you just want to call him as a court's witness and see if more issues come up. Or
Do y'all have an issue with presenting the next phase that you want to argue as far as whether we import jurors or export the trial and then hear from the sheriff, or do y'all have a...
Whichever way you want to handle it, Your Honor, we have an argument.
Well, yeah, let me hear your argument, and then we'll let the sheriff testify, and each side can ask whatever questions you think may be appropriate.
Thank you. Judge, I appreciate the dilemma that the state has about bringing witnesses and that sort of thing and wanting justice for the citizens here, but I'm concerned about justice for my client. I'm concerned over getting a fair and impartial jury. That's more important. If you're asked if the state has brought this case that's pretty unusual, only 2 cases have been brought of this nature. If you're going to do that and ask somebody to stand trial for murder, it doesn't matter how much money it costs. It doesn't matter how far you have to bring witnesses. That doesn't have anything to do with it. There's no case law anywhere that says you need to decide where the cheapest place you can go and where the easiest place you can go. That has nothing to do with it. What we need to do is to find a place where we can get an impartial and fair jury. I don't think anywhere in this epicenter are we going to be able to find that. So it's going to be a problem. I've been doing this 54 years now, and I've handled a good many death penalty cases where we moved jurisdiction. And demographics are important because, as the state said, you don't want to pick a place that has 8,000 people and you're almost 100,000 here. So what we did is we went through and looked at counties that we felt like had different media coverage. And just as an example, the state said, well, there were 50 hits in Savannah. How many hits were here? How many hits were in Atlanta? How many hits were in Gwinnett County? I bet it's 500 times that. So if you're talking about 50 hits in a place that has 71,000 people, that's not a whole lot of hits. There's no question, like for instance, Thomas County. Thomasville is the county seat. They get most of their news from Tallahassee. They have their own news station there. I'm sure that this case has hit the media almost everywhere. But what we want to try to do is limit that as much as possible. Limit the ability for people to make up their mind about a case before they hear the evidence. The state says, well, you know, he wasn't involved in the shooting, but they are making him involved. They're going to bring all of the people that were at the school, all of the victims, and they're going to show all of these things that he was involved, that he did something to cause this. So it's kind of hard to argue, well, he's different than Cope. Well, it's not, because they're going to bring exactly the same evidence. So to argue that, I think, is a problem. We have asked the court to look at a number of counties that are far enough away that the media is not going to be an impact, or the social media is not going to be an impact, where people have not already made up their mind, where people haven't gone to rallies, they haven't given money on FundMe, they haven't gone to a restaurant that has a sign in their window. That's what we're trying to avoid. Walton County sold, they had 2 or 3 companies there that sold T-shirts, Apalachee Strong. So, you know, I said, let's move it over to Walton County. They're part of the same, as the court explained, the bomb that went off. And you got to get far enough away from that bomb that you're not going to get hurt. And that's what we want to try to do. The Effingham County, Glenn County, Camden County, Bryan County, all of these we went through. We got the demographics on each one, the number, the population in each one. So we feel like, Judge, that we need to get far enough away that we don't have an issue. If we start picking a jury, and there's a certain percentage, if we find that people have heard about the case, they made up their mind about the case, we're going to have to turn around and do it again. So when the state says, well, we want to eliminate as much error as possible, well, that's not eliminating the error. If we're going to bring people in that are really close to that epicenter, and then we can't get a jury, then we're going to have to do this again. I think it would be wrong not to move the case far enough away that we're not going to have a problem. Thank you, Judge.
Your Honor, I did just want to clear up about there's no case law about looking at how expensive it's going to be. OCGA 177150, which is the procedures for change of venue, which is a statute in this case, subsection 3 says, the judge shall consult with the Chief Superior Court Judge of the circuit in which the county of transfer lies and consider all of the factors provided in subparagraphs A through L of paragraph 2, as well as the following factors: the hardship of sequestration and distance from the jurors, comparison to court space available, the comparison to security, jail, clerical, support staff, the cost to conduct the trial in each place, the impact of the trial on the orderly administration of justice, the impact on the witnesses, the availability of hotel accommodations and meals for jurors, the effect on the prosecuting attorney and defense counsel in each case, and all other matters which would afford a fair trial and the orderly administration of justice. The law says you shall consider these things. So it is proper to do that. And when you look at that, Your Honor, we called the different DA's offices that they talked about. These are very far away. They're a lot smaller jurisdictions. And in fact, in Bryan County, Your Honor, which is one of them they talked about, they've been operating out of a satellite location for almost 3 years because of the tornado that came through in 2022. So the courthouse is still trying to figure out their physical layout. They can't have this trial.
Why don't we do, let's hear from the sheriff, and then I'll give you guys final word.
I think call Jed Smith to the stand. raise your right hand, please. Swear the testimony together, matter of opinion before this court will be the truth, the whole truth, nothing but the truth, so help you God.
So help me God.
Okay. Have a seat, please. Now, we all know who you are, but could you introduce yourself for the record, please?
Sheriff Judd Smith, Sheriff of Barrow County, Georgia.
Okay. About how many deputies do you have employed in your service?
I have about 225 total employees, but sworn about 125, 130.
Okay. And what kind of, do y'all have to handle security at the jail?
We're a full-service sheriff's office. We handle security at the jail, the courthouse, the road, investigations, schools. We're full service.
On the day of September 4th, 2024, do you have an approximate number of deputies that responded to the scene of the crime at Apalachee High School?
There were over 140 law enforcement officers from the surrounding areas and the county, but about probably 70 or 80 from our office.
Okay. If 75 deputies are on the witness list, now, I don't anticipate we'll call all 75 deputies as witnesses, but if a significant number of those deputies were called as witnesses at a location that's more than a day's drive, you would have to spend the night there as a witness. What kind of impact would that have on the services that you provide to Barrow County?
It's an impact that I couldn't even fathom in my mind, really, because it would leave the citizens, in my opinion, in Barrow County in a not so safe manner, having deputies other places at that time with that many, if that was the number.
Okay. And do you have to still provide security for the courthouse in this county?
I'm constitutionally under the duty of a constitutional sheriff. I have to here.
Okay. And would you also have to help with the security at the county we went to?
That's correct. With permission of the sheriff, I would have to ask permission to be there to help him. I would then have to have security here, as you stated, and I may have to contract with another sheriff's office, if that's even a possibility, for them to relieve their citizens to come and help Barrow County while we've moved.
And would you have to help provide security for a jury that was sequestered in another, that was sequestered here? Like if a jury is brought from another county and brought here and sequestered, would you have to provide security for them?
24/7, yes.
I don't have any other questions, Your Honor. I do have them open for the court or the defense to
Sure. Just a few questions for you. You said there were 140 law enforcement that came. Where were those law enforcement officers from? What counties did they come from?
Barrow, Walton, Jackson, Oconee, Gwinnett, later on Hall and Forsyth after the incident, but that was the initial.
So you had these officers
GSP
from,
as well, excuse me, I didn't interrupt you, federal and GSP. So.
right. And the 75 officers that you indicated came from your office, how many of them actually did any investigation?
I'm not certain. I'd say 10 to 15 at least, in different capacities.
And of those 10 or 15, were there any of them that did anything significant? How many of them would have done that?
Respectfully, everything they did that day was very significant.
Okay, so a lot of them did similar things, trying to marshal people together. And,
Yes, sir.
And the GBI came
Yes, sir.
and did their investigation, right?
Yes, sir.
And they kind of took it over, right?
We were lockstep together with the GBI. I'd asked them to help us, yes.
Okay, so we're not talking about really bringing all 75 people. We're talking about maybe 10, 15 the most.
My office is not in charge of bringing the witnesses. That
Sure.
would be the state, so I can't speak to the number that would be brought, or that would be up to the subpoenas to the court.
Okay, and when you have a jury trial here in your county, how many officers do you use for that jury trial?
For a jury trial, it could be between 10 to 12 at a time,
Okay.
depending on the case and what we got. But because we have other cases going on in this courthouse, we have other courtrooms that might be filled and have people there. But they have to have breaks, and so we have to have backups, if you will, plan A, plan B.
So the bailiff is the one who actually deals with the jury. You don't have any of your officers that deal with the jury, correct?
If that's the court and they require that a bailiff, yes. Mm-hmm.
Okay. Most of your deputies then would be for security?
Yes, sir.
Okay. Have you ever been involved in moving a case outside of this county?
Not that I'm aware of, no, sir. No.
Okay. Do you know how many, you don't know how many officers might be provided by the county that you might go to?
I have no idea. I'd have to consult with the sheriff of that county to determine what staff levels he has at that time.
Great. Thank you.
Any further questions for me?
Your Honor.
I don't have any. Thank you, Sheriff.
Thank you, Your Honor.
Mr. Berry, did you have any final argument? I know that.
Judge, we still have the position that we need to move this case far enough away that we don't have a problem that we're going to have to redo the case again. And I've been involved in cases where we have picked a jury in one county, brought them back to the county. That never really works well. If this case takes a month to try, you're going to have people really mad that they're not able to go home at night. It's going to cost this county a lot of money to feed them breakfast, lunch, and dinner and house them for a whole month in this county. That's going to cost a lot of money. It's going to cost probably as much money as it would to bring people back and forth. So the only way that I see that would be the best way to handle it is pick a county, one that's far enough away, has similar demographics, and we can try it there. It's a problem. We don't like to be away from our homes either, but that's just the way that it should be. You know, whether it costs the county money, whether it's a problem for the county, whether people don't want to be away from home at night, I'm sorry. But the state's brought this case. It's an important case. It's a novel case. And we need to be sure that justice is done. Thank you.
Your Honor, this is not just about money. There's also the issue of practicality. You have these witnesses are minors. So now you have to bring a minor down here with their family because they can't come by themselves. All of these other witnesses, are there enough hotel rooms to even accommodate all these people? And are you going to have witnesses in the same hotel with defense counsel, in the same hotel with Channel 5, in the same hotel with deputies, and where are the jurors eating? And it's like, there's a practicality to all this that makes it almost impossible. And anecdotally, I tried a case in Jackson County where a deputy was shot. And it happened in the courthouse, so a lot of the witnesses were courthouse personnel. And they got short-staffed, and the higher-ups knew what to do and what not to do, but somebody, probably lower down, mid-level, called an audible because we're short-staffed. And they called the victim of the shooting to come run the metal detector at the front entrance where the jurors came through. And he greeted all the jurors as they were coming through, the victim in my case. And we had a mistrial. It's things like that that can happen. When you add the complexity and people are doing things they're not normally doing and they're moving and they're shorthanded and decisions get made and things happen that causes error. The way we can make this as more like a normal trial as possible, the best chance we have of doing this once.
It's y'all's motion. You get the last word. We're going to have to cut it off after your last word here. And then, but anything else you'd like to say?
You know, the only thing I can say, Judge, is sometimes there are errors. But as we see, there's not going to be that many officers probably that testify. The GBI did most of this investigation. They're not going to bring all of them down at one time anyway to testify. Usually you stagger those witnesses. So I don't really see that there's a problem. There are motels. I tried a case in the area where there's only 3 motels. We found a house. We stayed in a house. We didn't stay anywhere close to the jury. So there's ways to get around all of these things. You can't just say, well, there's not enough motels, there's not enough restaurants. If you pick a place that's got 75, 100,000 people, you're going to have more than one hotel or motel, and you're going to have more than one restaurant. So I don't see the problem that the state is seeing. It's just one of those issues. When you bring a case like this, you got to move it somewhere that you're not in the epicenter. That's just the bottom line.
I mean, there are 1,000 things that could go wrong that derail us from having what I'll call a clean trial. And there are 1,000 factors to consider in deciding where to go and whether we import jurors or export the trial. While, it's going to be expensive no matter what way it's done, that is a factor. It's not foremost on the list of things that I've got to consider here. Just some practical problems with exporting the trial. I was told it's probably a 3-week trial. So I've got to find a courthouse that can accommodate us for 3 weeks if we export the trial. I've got to make sure that place, we're on the higher end as far as courtroom technology. I've got to find a place where the evidence can actually be presented in some sort of efficient fashion. There are a lot of difficulties in taking the case elsewhere. There are a lot of risks in keeping the case here. Jurors are sitting in the box, and if they're from Walton County, odds are that courtroom will be full, and somebody in the courtroom will recognize a juror or two from Walton County. And then they will reach out to them and taint our jury, or that they will message them on social media. And, so the closer we are to the epicenter, the more likely it is people know jurors or see jurors at their kids' rec ball game. And that could derail what we're trying to do here, is have a fair, clean trial. So I'm going to look at all of it. I will reach out to various jurisdictions, and I'll issue an order. So obviously venue will be changed. It will not be a Barrow County jury. Both sides agree as to that, and I'll have to figure out if we're going to export the trial or import jurors. But it's going to take me a minute to reach out to other jurisdictions and figure out the best way to do it. So I'll issue an order, and we'll endeavor to do that within 30 days as required. I would also like to get us a scheduling order in place so that we can talk about making sure that we stay on track for a September trial. Have you all talked about the scheduling order at all?
We have not, Judge.
Good.
We'll be glad to sit down with the state and see if it can work out.
Is there anything you want to address with respect to a scheduling order today?
I don't think anything from the state. We can discuss it. If you could kind of give us an idea of specifically what you want in a scheduling order. I know discovery deadlines and motion deadlines. And I assume in this case we'll want to do voir dire question deadline. Is there anything else you would like in it?
Those were the big ones. I do want voir dire questions in writing in advance of trial, and we can talk about what that looks like. I always, because voir dire is part of the trial strategy, I don't think it's appropriate in the written questions to give the state's questions to the defense and the defense questions to the state. It's each side would essentially submit it to me in camera or ex parte. I would let that side know which questions I had an issue with, and then at an appropriate time, they could have, if they believed I was wrong, I'd hear argument on it in advance of jury selection. I definitely do want a deadline for motions to be filed so that we're not at the last minute having to address some, either a novel legal argument or something that's going to take considerable research and time to rule on. I certainly also want a deadline on completing discovery. I don't want 2 weeks before trial the state to give the defense 1,000 digital images or pages of something that they just obtained, but then the defense says I don't have time to go through 1,000 pages of whatever that exhibit is, or now that I have that, I need a continuance. So I'm certainly concerned about having a discovery deadline. Same with witness lists. I mean, all those things are standard, but I want to make sure that this is a year old. We're talking about a September trial. I want to make sure that we all have all of those things squared away in advance of trial. I do have different dates that we can hear motions. I think presently we've got some scheduled in May, or at least a day reserved in May. I don't know that there's anything that's been docketed for that day. I've got some other dates that right now I'm keeping open for future motions or issues that we need to address, and I'll share those with you all and find out which ones work with your calendars and schedule. But I'll let y'all talk first and see if you're able to agree on a scheduling order.
So when would you like us to give you a proposed scheduling order by?
I mean, could you guys do one in 10 days or so? A proposed scheduling order?
I think so.
Yeah, I think so, Judge.
Okay. So I guess that somewhere around the end of next week, if not the beginning of the week after. Okay. Anything else?
Not from the state, right?
Not from the adventure.
Okay.